Hi, Dwayne from Pissed Off Parent here to talk to you all about custody interference, violation of Texas Penal Code 2503. Interference with child custody 2503. A person commits an offense if the person takes or retains a child younger than 18 years of age when the person knows that the person's taking or retention violates the express terms of a judgment or order, including a temporary order, of a court disposing of the child's custody. When the person has not been awarded custody of the child by a court of competent jurisdiction, knows that a suit for divorce or a civil suit or application for habeas corpus to dispose of the child's custody has been filed, and takes the child out of the geographic area of the counties composing the judicial district if the court is a district court, or the county if the court is a statutory county court, without the permission of the court and with the intent to deprive the court of authority over the child, or outside of the United States with the intent to deprive a person entitled to possession of or access to the child of that possession or access, and without the permission of that person. Now, there's additional requirements put on the non-custodial parent, which is about 90% of the time the father. A non-custodial parent commits an offense if, with the intent to interfere with the lawful custody of a child younger than 18 years, the non-custodial parent knowingly entices or persuades the child to leave the custody of the custodial parent, guardian, or person standing in the stead of the custodial parent or guardian of the child. And there's other information in here that talks about remedies and things like that. You can read on your own. But that, in a nutshell, is interference with child custody 2503. Let's look at a typical scenario that's played out all the time. Visitation day. Right when it's time for dad, 90% of non-custodial parents are dads thanks to the Title 4D funding, goes to pick up his waiting children. Mom calls them in or takes them away. Dad waits. Dad gets mad and calls the mother asking about the kids. Mom gleefully takes pictures for her Facebook account, makes some silly comments, and hangs up on Dad. Dad knows about 2503 and knows that the court always prosecutes 2505 2 sections down, and then calls the police. The police show up and he explains the situation to the officers in great detail, and it turns out pretty much like that court scene from Idiocracy. The police end up telling him it's a civil issue. He even shows them the paper where it clearly says Penal Code and violation. Same result. So you filed multiple 2503 violations, and now you think that the district attorney is going to prosecute. Well, think again. The Children and Families Group conducted research and collected data from 727 police departments and DAs and sheriff's departments from all 254 Texas counties over 10 years. The team found that there were 1.25 million divorces in Texas, affecting over 1 million children across the state. 4 of the 5 largest cities in Texas had 0 arrests for the 10-year period of that study. Of the 700 largest cities and towns, 595 had no arrest at all in 10 years. 85% of the largest cities had 0 arrests in 10 years. Why? Well, Title 4D funds and all the money they receive from the government through the family court system. Remember, it's a $60 billion a year industry. The district attorney can't afford to put in jail their bread and butter. Remember, Texas alone recoups $786 million a year from Title 4D funds. Now, the state has their battery. With all this information, what can you do? 1. Remain calm. I know it's impossible, but for the sake of your kids, you've got to remain calm. 2. Download a copy of the Visitation Enforcement Kit, the link's on my website, and it walks you through all those hoops that the court's going to have you jump through. It's going to have information like, ensuring that you're at the correct location in time for the pickup, and that you knock on the door and ensure the other parents are aware you're there to pick the kid up. 3, obtain evidence that you're at the correct location at the right date and time. Purchase or get a receipt at a local nearby store or restaurant. Contact the police department and see if they'll file a report. At the very least, they have to note that you were there and what it was for, and it's on the record. You can try to show them your paperwork, but we all know what's going to happen. You're going to hear a civil matter, but you got to stay nice. Video and record, get a timestamp, bring a witness, and then any other evidence that shows you were there at the right time. 4, complete that visitation journal. And see if you're going to have the officer, maybe he or she will sign and date it for you, so you have that additional information. And then after a number of times of that happening, you can send notice. There's a link with that information as well on my website, but you want to send notice via certified mail or some way you can track it to their parent and let them know that they did not honor the court order. And then after this happens a number of times, not just one, not 3, it needs to be a number of times, then you need to follow the remaining steps on the enforcement kit. Now remember, the other parent, the state, the judge, everybody else wants to find a way to perpetuate this nonsense. Be a pissed off parent and beat them at their own game for the good of your kids. But understand it's going to take a lot of time and perseverance. There's an article on my website that goes into more detail and discusses it from different perspectives. Well, I hope this educational video has helped you out. And until next time, this is Dwayne, the Pissed Off Parent.